So we are here today just to have a bit of a discussion on the nuts and bolts of remote appearances, as well as some jurisdictional issues. We're going to follow this with hopefully a question and answer period at the end, if there's time permitting. So if you have questions during the presentations, just feel free to put them in the question and answer in the chat box at the bottom, and then I can read them out to the presenters. So just for a bit of background on our presenters, if you don't know them, we have Judge Chisholm, who sits on the territorial court. Judge Chisholm graduated from Dalhousie University Law School in 1989, and he was called to the bar in Nova Scotia in 1990, where he worked in private practice in Halifax before moving to the Yukon in 1992, where he joined Preston, Willis, Leach, and Lakowitz. While in the Yukon, in addition to practicing law in the private sector, he worked as counsel with legal aid and as a Crown prosecutor. He was also counsel with the Public Prosecution Service of Canada in Ottawa, and was chief federal prosecutor for the Atlantic region of the PPSC based in Halifax, when he was appointed as a judge of the Territorial Court of Yukon on July 31st, 2013. And he served as chief judge of that court from April 8th, 2018 to April 7th of 2021. Our other presenter is David McWhinnie. David's been in practice since 1984. He served as a federal prosecutor for nearly 30 years, retiring from the Public Prosecution Service in 2017 as general counsel. His prosecution duties took him across all three territories, along with periods of service in the Federal Crimes Against Humanity / War Crimes Unit, and later the Proceeds of Crime Unit. He was primarily a criminal trial lawyer, but also did substantial criminal appellate experience. He was first called to the bar in 1984 and is currently active in Yukon private practice. He was previously active in the bars of the Northwest Territories and Nunavut. David is currently a member of the Yukon Law Society's Discipline Committee, as well as the Society's representative at the National Federation of Law Societies. And David also serves as an outside mentor / practice advisor for the Yukon Legal Aid Program. So without further ado, I will let you two take it away.
Thank you, Kathy. I think as we discussed it yesterday, I was supposed to provide an initial outline of what has happened, what has been changed, and maybe some, at least at the outset, some insight, I hope, as to where this may be going. For those of you who had a chance to look, you'll see that in the last round of major amendments to the Criminal Code, Parliament brought in what is now known as Section 22.01 or 01 of the Criminal Code, which deals with remote appearances. It is, I would style it an extension of things that have been happening in the Criminal Code for a period of time, most significantly and in most detail over the last number of years with respect to witnesses, which is in the immediately preceding section, Part 22, Section 714, and those that follow just preceding the new Part 22.01 are ones that many of you are probably already familiar with and familiar with the changes in. This area dealing with appearances before the court is somewhat convoluted, I think might be the best way to describe it, because there are a whole series of interlocking and sometimes completely contradictory provisions in the criminal code and in the common law that address the issues that deal with where the court is, who is in the court, and what the court can do depending on those questions, and where things that are said to have happened or are going to happen actually did or are going to take place. Without going down the long, and it could be quite a lengthy historical review, and if you are interested, the Tu Youngman case that is cited in the materials that Kathy Rasmussen provided has a quite good summary and history of how we got through to some of the things that were to where we are now, and to some extent provide some insight into where we may be going. Reduced to its simplest, I think you can make a pretty good case that for many, many, many years, there's been a very tight link between the physical place that a court was, which governed sometimes who was permitted to sit in that particular court and conduct certain kinds of proceedings, a physical jurisdiction, and then a jurisdiction with respect to the people or the subject matter. And when you go back through some of the cases in the not so distant past, those two questions, jurisdiction over the person and jurisdiction over the offense, are the central issues that the court is normally concerned with. For many years, the assumption has been the court wouldn't even be dealing with an issue as long as the accused, the witnesses, the lawyers, everybody concerned was actually in the physical jurisdiction and, for the most part, in the same room as the presiding judge, justice, or court, if it happened to be a jury. Over the last 30 or 40 years, there have been various amendments and changes and encroachments on those things, reflecting the, amongst other things, the changes in the world and the changes in technology and the necessities of trying to conduct court business in a modern era that have touched on or encroached on or significantly changed all of those long-standing hard and fast assumptions, such that we now find with the new part 22.01 what I think may turn out to be a major change in the law on the subject, or on these subjects, and how it all works. In years not so far past, we had in jurisdictions that had, for example, county courts, you would have judges or justices that may be appointed for that particular county court. They had no jurisdiction to sit or hear cases that originated in or were being heard in another county or another judicial district. You'll see in the criminal code in some of the more, I'll call them elderly provisions that go back to those times, provisions about how a judge, if they are in one judicial district and somebody shows up in custody in that province, can send them or transmit the matter and the accused to the county court or jurisdiction having the geographical connection to the matter. Over a series of years and amendments, that has become less important, but I suspect in some places, such as Ontario, there might still be judges whose jurisdiction is more geographically limited than just to the province they are in. There are also then issues to do with things that happen outside the province. And so as an historical example, for a very long time, a Superior Court judge could issue a subpoena that was intended to be served on a person known to be outside the province or territory where that judge was issuing it. That was not possible at all for a territorial judge or a JP. Through a series of amendments, it's now possible for a territorial judge to issue a subpoena that's good anywhere in the country. But that was within the last 30 years that amendment came in. If a justice of the peace issues a subpoena, if it isn't for somebody within the province in which they are, there are special rules. That's the context that the trial issues are within. And so when we looked at the conduct of a trial, the assumption and presumption was, and according to even the new amendments still is, that everybody essentially for a trial will be in the same room at the same time conducting the case, unless. And all of those amendments that I've been talking about are a series of unlesses that have been brought in to deal with various and sundry issues. If you go back through the criminal code, you'll see a couple of key ones that help you understand or put this in context. Section 650 is the one that is the core one, in that it prescribes very explicitly that the accused must be present in court during the whole of his or her whole trial. That specific rule contemplated personal attendance before the judge, and by extension, any lawyers that were involved had to be there as well. And so you'll see exceptions provided, for example, in the provisions dealing with child witnesses that say, despite Section 650, a child witness can appear by video from a different room. And the concept that is embraced there is that this is an exceptional thing, having a witness outside of the room in which the trial is taking place. When they made some amendments to Section 650 to allow for, I'll call them administrative or key issues or non-essential matters, administrative matters may be a better term, there were provisions made in the criminal code in 650 that said that there were an exception that an accused could appear by video for certain things, where as long as evidence wasn't being called. It should be noted that those provisions, 650.1.1 and 1.2, deal with accused who are appearing for something where evidence is not being taken. The first one, 1.1, requires the consent of the accused and the agreement of the prosecutor, essentially, to do things that are part of the trial. So taking a plea or pretrial motions or various other things, as long as evidence isn't being taken, you could do it by consent without having the accused physically in the room with the judge. There was an exception, modified exception, provided for an accused to appear by video conference, again, as long as evidence wasn't being called, to deal with, I'll call them non-trial matters, not the actual hearing of the evidence, as long as they could communicate with counsel, but the court had to be satisfied that the arrangements were adequate. When they brought in the new 22.01, they brought in a set of amendments that essentially filled some of the gaps between those provisions in 650 and the earlier and somewhat modified over time provisions in Part 22 dealing with witnesses, where they now have a specific provision in 715.23 to address whether and how the court can order an accused to appear by audio or video conference, a provision in 715.25 for participants, which is peculiarly defined, I would say. It's defined by who are not caught by that particular provision. So because there are specific provisions for accused, for witnesses, for judges and justices, and a fairly extensive set of provisions which don't deal with remote appearances in another place, participants is everybody but that list of people. And so the first and foremost people will be court officials and lawyers. And so the court can direct that a lawyer, defense or crown, can appear before the court by remote appearance, audio or video, assuming that the criteria that are set out are met and that the different provisions are provided for. 715.26 also provides that the judge can appear or preside by audio or video conference if it's necessary or appropriate in all the circumstances. And there's a set of criteria that are set out. If you compare 714.1, which was the much earlier and the initial provision that dealt with the appearance of witnesses before the court, with 715.23 and the other two, you'll see that they are very similarly structured, very similarly worded. There are some parts that have been deleted and a few additions, which in the long run, I think when we're looking at and comparing cases, the interpretation of the provisions under 714 will be helpful to counsel, but have to be used with a grain of an element of caution, because certain things that appeared in 714 and certain things that appear to be presumed in section 650 and its companion 573, or 537 rather, which deals with preliminary inquiries, are not exactly the same. And it's my suspicion that over time we're going to see a fair bit of litigation over those differences and their significance. We're already starting to see it. So if you look to 715.23, which is the one that is probably the one that's going to be most controversial simply because it deals with the accused, you'll see that there's a set of criteria that govern what the court is to consider: the location, personal circumstances of the accused, the cost to be incurred, the suitability of the location from which the accused wants to appear, the nature and seriousness of the offense. All of these presuppose, I would suggest, that there's an application to the judge to do this, and that it'll be supported in some way by likely an affidavit giving the court the information to consider in deciding whether or not those criteria are met. An important difference, even though the wording of 715.2.3 very closely tracks the earlier 714.1, which dealt with witnesses, an important difference is the last consideration in 714.1, whether or not there's a question of prejudice to the accused, is omitted in 714.2.3. Another important difference for 715.2.3 versus 650 is the consent of the accused or the Crown are not explicitly indicated as being required. And so we have, because when Parliament brought these things in, they didn't amend some of these other interrelated provisions. We actually have some, if not directly conflicting, not entirely consistent provisions as between the touchstone provision, section 650, and this new part 22.01. The key one being whether or not the accused's consent is required and for what. And so if you look at it, the current somewhat anomalous situation appears to be that if it is desired by the Crown to have the accused who is living some distance away and not able to attend appear at a pretrial application where evidence is not going to be called, they could apply under section 650, but the accused's consent would be required. They both have to agree. If they apply under section 715.2.3 and the court is satisfied that the application in question is part of the trial, the accused's consent is not required. And to extend that a little further, for the actual trial portion of the application, the Crown likely has little or no resort to section 650.1.1, but instead has to go directly to 715.2.3, and the issue of prejudice and the issue of the accused's consent are seemingly not on the table. It's not clear to me why these pieces have been omitted. Section 650 was left as is, and section 650 has some provisions that address specifically that essentially, not unless otherwise provided in the criminal code, then the general rule that the accused shall attend personally is the touchstone, and that's repeated to some extent in 715.2.1. It restates that the presumption is in favor of personal attendance, but then they've gone on in 715.2.2 to talk about the principles that they're trying to accomplish. Another one of these more recent drafting things that we're seeing in the criminal code, where we see a statement of purpose where they talk about the rules of court and ensuring fair and efficient proceedings, without much criteria anywhere as to what the measure of efficiency, how we're to do that. And fairness is a very, very uneasy word to use in my submission, because in different contexts, fair will mean quite different things. That part may have been intentional. And I suppose it could be argued that the reason they didn't provide some of the same explicit provisions in this section is that they were assuming, that is, Parliament was assuming, that judges would import into the analysis of 715.2.3 or the related sections the kinds of premises that have shown up in the case law interpreting section 650. They didn't actually say that, and it's an assumption that some judges have applied, not all the judges have. When you go through the case list that Ms. Rasmussen provided, you'll see a couple of cases, Candelaria and Daly, which are both Ontario decisions from 2020, where the court was wrestling with what to do with accused who were in custody who wanted to appear before the court to enter guilty pleas and be sentenced, but because of COVID weren't able to come personally, and the video facilities either weren't available or weren't adequate. And the question came up, could the court receive these pleas and deal with the sentencings or not? The narrow line of interpretation of section 650 as that will later inform the part 22.1 from Justice Downs, was 650 was intended to be narrow, prescriptive, if I can use it that, and limited. If it didn't say you could do something, you couldn't. And so because 650 was preserved by the new part 22.01, the fact that the appearances for sentencings in that section were described as being restricted to video conference meant you could not do it by telephone. And so in the case of Mr. Candelaria, it appears that he didn't really want to do it by phone. That was really the only choice. And so in light of what happened in the subsequent case of Daly, I'm suspicious that it was somewhat fact-driven, to be fair. Mr. Candelaria apparently did not want to do it by phone, did want to appear in front of the court, did not have a lawyer, and as I recall, what Justice Downs had to say about him was struggling. And so it may well be that the decision there was less about the strictness of the principle than the premises of the justice of doing it in the fashion that it was proposed. The judge did make some comments about wanting to see more video facilities available. In Daly, we had a somewhat similarly situated accused in custody, unable to come to court because of COVID and not able to access video. However, he was represented by counsel, was content to appear by telephone, and it was a situation where the judge's analysis had to look at the fact that if they didn't do it this way, he would run over the sort of fair sentence imposed by time served, and so an injustice would have been worked by refusing to hear it that way. In that case, the court determined to not follow the reasoning Candelaria, but took a more liberal interpretation to do the right thing, but did include a caution that these departures from the norm, if we can call it that, should be relatively rare and carefully and thoughtfully done. That was amplified in the first case. It's on Ms. Rasmussen's list, court file number 19578. There, the accused wanted a complete trial, a virtual trial. The court, having a fair bit of material, including, as I recall, dress rehearsals to consider as to whether this could be done fairly and properly, decided that it could be done with the accused's consent, but laid out a fairly broad set of considerations and concerns that should be addressed in order to ensure that the fairness and justice part of the proceedings weren't sacrificed in the interests of interests or efficiency. Those issues, I mean, efficiency shows up in the 715.22 statement of principles, or the purpose statement. There is a decision from Madam Justice Cooper in the Nunavut Court concerning an application by a defense counsel to appear remotely on a matter in their court. Ultimately, she decided, having regard to the provisions, that efficiency was not all, I think is almost a quote from what she had to say. She was of the view that, at least with respect to defense counsel, a video appearance was not an adequate substitute for personal attendance. The realities and the necessities and exigencies of being counsel for an accused person whose liberty interests and justice interests are very much at risk and potentially changing moment by moment seemed to her, as I understood her decision, to call for a more immediate presence of the counsel and the more intensive access to his or her counsel than a video appearance would do on something that was more than a mere procedural appearance. She left open the question as to whether it would be different for Crown Counsel appearing, say, at a trial. Reading between the lines, it seems to me that following along some of the earlier decisions in Ontario, particularly where if you're going to depart from the norm, you do so in a principled way, it may come down to something along the lines of, when considering whether or not to agree with this proposal, the court should look at the downside risks. if the Crown does a poor job of presenting a case, arguably, and in the ordinary case, the biggest risk is that maybe a guilty person might avoid a conviction on a technicality or a failure on the Crown's part. The reverse proposition that if defense counsel is inadequate for some reason or fails to assist as fully as possible could result in an innocent person being convicted is simply untenable. And so that may be part of the underlying value statement that drives Justice Cooper's analysis, that it's potentially open for different rules to apply to different types of counsel. It is, I think, likely going to be the case that the nature of the application may also drive it if that kind of reasoning applies. Already in the preliminary inquiry proceedings provisions, there's a provision dealing with accused people who are awaiting a preliminary inquiry. The rules regarding attendance of the accused are fairly strict in preliminary inquiries. That's down in section 537. But there is a little wider, it seems to me, discretion allowed to the court to allow an accused to appear or be absent altogether, which there is in 650, but is very narrowly construed for the most part. And so it may be that if someone is relying on Part 22.01 to have an appearance, a virtual appearance or a virtual hearing, a preliminary inquiry might be something where that would be more readily agreed to than if it were a jury trial at the other end of the extreme, or the other end of the spectrum. There are some decisions, at least early ones, that have dealt with the question. One in particular is a decision of Judge Gorman from Newfoundland in the Singh case, which is on the list of cases you have, where he was faced with an issue of what to do in the case of an individual who was supposed to attend for trial in Newfoundland, but was resident, I believe, in BC during the COVID inquiry, the COVID period and provisions at the time. Getting into Newfoundland was difficult, and there were fairly significant restrictions and isolation requirements and that sort of thing that would have made it quite expensive and difficult for the accused to go in person. In that case, the accused did not wish to have a trial remotely, but wished to attend in person, and in essence was seeking an adjournment in order to wait for things to settle down on the COVID front. Judge Gorman did not grant the adjournment. He went through the analysis that he believed their experience in Newfoundland informed, that conducting a trial remotely, in his view, in that particular kind of case at least, would have been perfectly satisfactory, and the fact that the accused didn't want that was not determinative. He decided that because there was the viable option of a remote trial, the adjournment was not granted, and that left it open, of course, to the accused to either appear as the judge had contemplated or to get on an airplane and go to Newfoundland. I do not know what the accused ultimately decided to do. The decision there then is clearly about whether or not to grant an adjournment, but the assumption that the accused's consent and his position is informative did not gain an awful lot of traction as I read the decision, and at least in Judge Gorman's estimation, we should be doing far more trial work by remote appearance. It's not clear to me where the defense counsel was resident, whether he or she was a resident of BC and could easily confer with the accused, or was in Newfoundland and the accused was going to be in BC. The Madam Justice decision, Cooper's decision in Issakark then might have been engaged potentially. There are some other oddities. Because there's no inclusion of a criteria as to whether or not the accused or the proposed participant is applying to, and therefore being asked to be permitted to appear remotely, the question becomes, at whose instance can these applications be brought? It doesn't appear to be any restraint. And so imagine a scenario where, for some particular reason, an accused person has a huge personal dislike of a proposed prosecutor. Can that accused bring an application to have the lawyer appear remotely? Can the court even entertain the question? And if it is made, if the application is made, could they grant it if the circumstances were considered some way appropriate to the court? And while that seems on the face of it perhaps a little far-fetched, one can imagine in the post-COVID, or the seemingly almost post-COVID world, where court time is increasingly precious, lawyers and counsel and people are away from work because of COVID. If it turns out that the one day that one Crown can be in court for a case that is about to run over a Jordan threshold, you could be met with a situation where, because of a personal antipathy, it may be desirable to have one person or the other not in the same room, each with the other. There's simply no guidance that I can see in the legislation to deal with that. I think I've just about used up my part of the time, so I'll move on to another issue that I think is a potential omission in the Part 22.01, and that is the deeming provisions that we see in 714 point, I think it's 0.6 if my memory serves. When they brought in the provisions dealing with remote appearances by witnesses, they addressed a number of different possibilities, which are, as I mentioned earlier, not really directly addressed in the new Part 22.01. They dealt with the issue of whether witnesses were inside or outside of Canada, and then there were different provisions and different criteria that applied, and different procedures that were either presumed or not presumed, depending on whether it was going to be an audio or a video conference. There was an inclusion of an ability to do things by consent, perhaps of some potential long-term moment is 714.6, where there were also a set of provisions that deemed, when witnesses gave evidence from outside the country at least, that the evidence they gave was deemed to be given in Canada, was given under oath or affirmation according to Canadian law, and that was for the purposes of evidence, procedure, perjury, and contempt of court. And so if you consider those questions in the context of the long-standing territorial jurisdiction, and this is of greatest significance in this territory for the territorial judges and JPs, where their jurisdiction, at least traditionally, legally, and unless explicitly changed, is confined to the territory, can a territorial judge hear a trial where the accused is in another province or territory? The wide open provisions described in 22.01 seem to say yes. There don't seem to have any reason why not. But if you apply the narrow interpretive reasoning line that was evident in Candelaria, I would suggest it's not necessarily a simple question. And even if it can be done, then the question becomes, for certain kinds of cases, questions become, well, where did the trial take place? If the accused testifies and perjures himself, the provision, there's no provision like 714.6 that deems his evidence to have been given in the territory. If he's on a phone in Saskatchewan, did he commit the perjury in Saskatchewan or did he commit it in the Yukon? And just to make things more interesting, there are a few oddball provisions floating around the criminal code that we all need to watch out for in a case where there's a possibility of a trans-border case. Some offenses, such as I think it's trafficking certain substances under the CDSA, the accused can be tried wherever he or she happens to be found. And so if a person appears by phone from Saskatchewan on a drug trafficking trial, if assuming that's one of the ones that's caught by that provision, is the trial taking place where he or she is found, Saskatchewan, or is it taking place in the Yukon? And by corollary, does a territorial judge have jurisdiction to try somebody in Saskatchewan? Question I don't know the answers are going to be easy to suss out. The simpler assumption is that it took place here, but to the extent that our provisions have traditionally been very geographically confined, I have some reservations. By happenstance for the Northern Territories, that is likely not as big a problem in the case of Superior Court judges by way of a closing exception to an exception. Justice Vertes, as he then was at the NWT Supreme Court, pointed out a number of years ago that Section 8 of the Criminal Code provides that the application of the Criminal Code it applies to the Northern Territories, except to the extent that it's inconsistent with the provisions that create those territories. And it turns out that in those three provisions, certainly the NWT and the Yukon Acts, I believe also the Nunavut Act, there's a provision that a Superior Court judge from those jurisdictions can sit anywhere in the country. And so there may be fewer problems in the Superior Court in the eventuality that a judge is out of the territory physically, or through some curious application of geography, a trial is deemed to have happened in a different province presided over by a Superior Court judge from the north. That's not likely as likely to be a problem. However, I'm not as sanguine about what happens if we have a trial with an accused in another completely different political jurisdiction from that of our territorial judges. I think at this point, having covered as much as we had, I should turn it over to Judge Chisholm for the view from the bench and maybe perhaps some of the practical problems from that side of the House.
Thank you very much, David. I hope everybody can hear me. So I do intend to discuss, in brief at least, some of the practical issues that I think Council have to keep in mind and be concerned about with respect to remote appearances. And the first issue that I would like to address is that of preparation of witnesses. Just as Council are expected to organize the logistics of calling witnesses in their case when the witness or witnesses are being called in person, the same expectation exists when witnesses are appearing remotely. However, it would seem that with a remote appearance, there are many more balls in the air, if you will, that Council must have their eyes on. I think that Council have to be aware that some witnesses, unless they're instructed otherwise, may not necessarily follow the decorum that one would expect in a courtroom. Practically speaking, Council must consider, I think, in advance that the witness is made aware, and that Council should make the witness aware about what the expectations of the court are likely to be. That translates into, for example, the witness not appearing in pajamas while seated on their bed when testifying. In this regard, I would recommend you to the Supreme Court best practices for video conferencing, which, as I understand it, Kathy Rasmussen has provided a link for in the materials you should have received. It's also essential that the witness has an appropriate venue to testify from, and the case law deals with this, and even pursuant to the code, that is a factor to be considered. So you don't want, for example, your witness in a situation where there's children running around and making noise. They shouldn't, for example, be testifying from their car, especially while driving. They should have a proper equipment, a charged tablet or computer or other device with a good connection to the internet. And there's other small things that you may want to consider that may not be relevant, but for example, even the time zone of the witness should be taken into consideration when advising, for example, when a witness is likely to testify. If you have a witness who's scheduled to testify from a courtroom or from a government building, say in Halifax, you don't want them to be scheduled to start their examination at 2 p.m. Yukon time, because you're going to undoubtedly run into some problems there. And similarly, when there is a great time difference, such as the East Coast of Canada versus the West Coast, I think that you want to try to plan for the witness not to be testifying at a time that they might otherwise be eating their dinner, because the witness might not necessarily live up to your expectations in that state in terms of how they testify. Another area that counsel should be concerned about is properly preparing their witness. It's always the responsibility of the party calling a witness to ensure that the witness is properly prepared. And part of being a good advocate is making sure that you've done everything possible to control what you are in a position as counsel to control. And that includes the proper preparation of witnesses. It's a given that a witness should, at the very least, have reviewed their statement, if any, prior to testifying. Better still, counsel might consider a mock run-through of a witness's testimony, which would likely be of assistance, and perhaps significant assistance to them. And this type of preparation, when a witness is appearing remotely, becomes, I think, more difficult. For example, arrangements are going to have to be made to forward the individual their statement, either by way of transcript and or recording. And I think as counsel, it's important for you to have at least a method to ensure that the witness has reviewed that statement. A mock examination with the witness may be more difficult logistically, but likely not impossible. If you were defense counsel and it's likely that you'll attempt to impeach a Crown witness, have you spoken to the Crown to ensure that the witness appearing remotely will have a copy of their prior statement or statements with them in the room from which they're testifying? Have you considered whether it's a good idea to have a witness testify remotely if they may be an uncooperative witness with whom you may have to resort to applications under the Canada Evidence Act? Have you thought about how you're going to have the witness refrain from looking at their statement when being cross-examined, except when you direct them to do so? And I think that most of those issues can be resolved, but the bottom line is you want to put your mind to it prior to the witness testifying. Secondly, I'd like to talk a bit about the role of the court technologist and interactions between counsel and the technologist with respect to a witness or an accused appearing by video. And firstly, I would suggest that if you're unfamiliar with it, you take the time to review the Territorial Court Practice Direction, which is Tech 3 or Technology 3 on requesting special equipment for court proceedings. And as I recall, the Supreme Court has similar timelines in terms of notice. In Tech 3, it speaks to notice requirements, And those notice requirements are to, of course, the court technologist. For example, if you have obtained an order for a witness or accused to testify by video conference, then 15 business days must be provided to the court technologist. And counsel should provide the technologist with the name and email address of the person who is to appear by video. And for her, because I've spoken to her about this, the file name and the scheduled trial date are of importance as well. It would be convenient if the file name and the witness name were included in the subject line. You can imagine that with at times up to 6 courtrooms running and remote appearances being quite common these days, that she receives many, many requests, and it just allows her to be able to organize her emails appropriately in terms of your matter. You should tell your witness in advance that that you will advise them of the anticipated time of day that they will testify, and that may not be something that you'll be aware of until closer to trial time, but they should understand that the court technologist is not in a position to tell them that, because she has no control over timing. You also should advise them to reply promptly to the court technologist for a request to test their internet connection, because in the past we've had situations where there have been problems with internet connections. She has a number of best practices to try to ensure that that doesn't occur, but that normally will entail her speaking to the witness and doing a test run, if you will. And additionally, you should advise her that if the matter is not proceeding, you should advise her if the matter is not proceeding. So if, for example, the matter is going to be resolved, or if from the Crown's perspective, the Crown is going to direct a stay of proceedings on the day of the trial, it's a benefit to her to know in advance that that's going to occur, because at times she's continuing to prepare for a matter and only discovers on the day scheduled for the matter that it's being adjourned, or as I say, it's being stayed. And I believe as well, in terms of adjournment, there is a requirement that you make another request to the court technologist with respect to the new court date. Number 3, I'd like to talk briefly about applications under 714.1 and 715.23 specifically. At the outset, I should point out that in many cases in this jurisdiction, as you're all aware, the court makes orders for witnesses to appear by video conference on consent of both parties. Undoubtedly, counsel realized that in many situations, having regard to all the circumstances, including the accused's right to a fair hearing, this is an appropriate order for the court to make. However, in other situations, whether under 714.1 or 715.25, the court may be asked to make a ruling. In such contested applications, counsel are well advised to provide a strong foundation supporting such a request. As you're aware, the enumerated factors to be assessed under both subsections or both sections are similar. One of the enumerated factors that a court is to consider is the, quote, suitability of the location from where the witness or the accused will appear. It would seem that this factor may include a consideration of the quality of the internet connection and or the device being used by the witness / accused. And I would refer to the decision that David McWhinnie has mentioned of Madam Justice Cooper and Regina and Isaac Yarak from 2021 NUCJ 36. The there's also a consideration of whether any practical and technological barriers must be overcome, such as the accused or co-accused appearing remotely from different locations or via different computers. And that issue was spoken to by Judge Cron and Regina and Barrett from the Manitoba Provincial Court, and the site for that case is in the materials. Or, for example, having more than 2 accused appearing from separate locations in the correctional center here in Whitehorse. If you look at the practice direction text 6, it indicates that no more than 2 accused are able to appear simultaneously from separate locations in the correctional center by video link. So that could cause some logistical issues if there are more than 2 accused individuals on the same information. Returning to the Isaaciarak decision of Justice Cooper, as she pointed out, the affidavit material in support of the application should contain sufficient information to address the relevant factors as opposed to being provided by way of counsel's submissions. And of course, the affiant may end up being subject to cross-examination before the court in certain cases. So those are some of the practical considerations I think that counsel have to keep in mind when dealing with remote appearances or applications for remote appearances. David, do you have anything else that you would like to delve into before we ask if there's any questions?
No, I think it's probably most useful to get into the questions if there are any at this point. Hoping that people have had a chance to reflect on that.
We don't have any at the moment. So if anybody has any questions that they would like to ask, either David or Judge Chisholm, if you can just put them in the question and answer chat thing or in the chat box, that would be great. So I'll give you a few seconds to do that.
I see that Mr. Drillette's name shows up on the list. I'm sure he must have a comment or a question.
Okay, here is a question from Paul Batten. Are there specific programs / networks that work best for remote connections? And I don't know if you've been made aware, if Sylvie's mentioned anything about that, Judge Chisholm, or from experience, David, if you know any that have worked the best.
That's a good question. My understanding is that there's been more success, I think, in this jurisdiction, at least, with respect to Zoom conferences. I know that in other jurisdictions, for example, in BC, they typically will use Microsoft Teams, but as I understand it, that's not something that we have tested here in the Yukon. So I think that would be my comment. I should say that at the beginning of the pandemic, when we started to have more remote appearances, we did try to get the best possible results, if you will. And as I say, I think that we've settled on Zoom as being the platform that works best for us.
And I have heard just anecdotally, I believe like if, for example, someone is appearing by using their phone or their home computer, just make sure they don't have lots of programs open. If they just have the Zoom or whichever is being used open, that does help with the connection as well. Okay, so we have another question here from Darcy. Practically speaking, what are the top 2 or 3 gaps that you have observed regarding remote appearances of accused and witnesses?
Interestingly, we've had some issues at times with RCMP officers, and although the issue may have been resolved, at times it appeared that an RCMP officer appearing by remotely via headquarters and whatever jurisdiction that they're in, there was a problem with the firewall that the RCMP had in place, and which prevented a good connection. I haven't seen that issue arise recently, so perhaps it's been remedied. But going back to my earlier point, I've had trial matters where witnesses have been called, and there have been issues in terms of location, issues in terms of interruptions, and so I go back to the point that it's important, I think, for counsel to try to control as much as possible in terms of remote appearances, and that means talking to the witness beforehand to understand what the expectations are. And I again refer to the best practices for video conferencing that was put out in September by the Supreme Court.
If I was to chime in, I would say encouraging a far more liberal use of the mute button is something that needs to be highly encouraged, because an awful lot of people seem to have difficulty with that. And if there are multiple people, like on the docket appearance day, trying to get through and be heard, it can be a real challenge.
Okay, we have another question from Kevin Gillette. How is the security of in-camera or ex parte proceedings protected?
Well, I wish I had the court technologist here to answer that, but I appreciate that security is an issue that has been raised in the past. We, as I understand it, have gone to a more secure Zoom platform than one might use in their home, for example, which is more of an open source. And so the platform that is being used here, as I'm led to understand, is one that is not easily hacked, if you will.
Okay. Those are the only questions we have typed currently. So I don't know if there are some other thoughts that either of you would like to share on this topic.
Just the observation that I think Mr. Gillette has put his finger in yet another either assumption by Parliament or a gap in the provisions, that when addressing the questions and the things that the court has to consider, what you are making an application to use a remote appearance for may be important, and they haven't provided a lot of guidance. Are there different rules if a judge wishes to appear or decides he or she wishes to appear remotely at a jury trial when evidence is being called, as opposed to closing submissions to a jury? If you are doing a voir dire, particularly in a jury trial, as Mr. Gillette points out, maintaining the security of in-camera ex parte proceedings becomes a mission critical. And so there are a lot of these kinds of questions that weren't addressed, and because of the conflicts between the existing provisions and the new provisions, there will be some challenges, I think, for the court to find their way through these complicated issues.
There's another comment / question from Mr. Gillette. It says in Accusero, the Quebec Supreme Court allowed an accused to be absent from his trial while it continued for the co-accused. The court required the accused to enter into an undertaking, not an order, to keep himself informed of the progress of the trial and communicate with counsel. So Judge Chisholm, what do you think of the undertaking versus an order? And for David, shouldn't the Crown have severed?
Well, in terms of the undertaking versus the order, I suppose I'm not sure if I have a preference with respect to one over the other. In terms of the order, I suppose that if there's a contravention of the order, then there's an immediate remedy. But I really haven't considered that situation, Mr. Drillette. So I'll have to think about it further.
I don't know the fact pattern that was involved, whether it was the co-accused who wanted to be absent for the bulk of the trial or the entirety of the Crown case, or just on the day. For example, in the Drabinski case, the defendant, Mr. Drabinski, in a co-accused case, was allowed to be away for, I think it was a single day or 2 days of a rather lengthy trial. And so in the analysis, the court was able to satisfy itself that the fairness of the trial to both accused wasn't going to be compromised. In terms of why it was an undertaking rather than an order, I suspect that has more to do with the wording of section 650 sub 2, which allows the court to permit the accused to absent him or herself from the trial on terms and conditions. But I don't recollect that it provides for making of an order that the person keep informed. The presumption seems to be that if under section 650 you are not in the courtroom, then you are not at the trial. You're not attending at all. And so sort of out of the reach of the court. And some of the early decisions that deal with appearances by remote video have assumed that that is the case for the purposes of doing their analysis, but they've left the question open. In terms of whether there should have been a severance, your experience, Mr. Gillette, and mine is the same. I suspect that there's a lot goes into that question, and without knowing the facts, I couldn't even guess.
Okay. So there doesn't appear to be any other questions. So I don't know if either of you have, oh, 1 second, we got one more. Okay, this is a long one. This is from Luke Fott. So pre-COVID, the practice direction for telephone appearances by counsel permitted them only in exceptional circumstances. And the practice direction further held that if counsel was located outside the territory, that would be deemed an exceptional circumstance. The results in a strange situation where non-resident lawyers get a benefit that resident lawyers do not. What's the rationale for not extending the ability to appear by telephone as a matter of course to resident lawyers? Busy docket dates and fixed dates can result in physically crammed conditions and upwards of 10 lawyers being physically present to speak to as little as one matter. Telephone appearances result in improved access to justice. Lawyers can bill much less for the appearance if it doesn't include travel time. Lawyers can multitask better than when waiting for their matter to be called.
Well, I guess the easy answer to that is that you'll have to ask Judge Cousins since he's the chief judge now. But my understanding in response to Mr. Fott's question is that in the pandemic era, at least, that there has been a changing landscape in terms of how counsel may, can, or should appear, but that as things presently stand, there's no reason why council cannot make a request to appear by telephone. I tend to agree with Mr. Fott that even in a non-pandemic situation, that there is a benefit, especially for private counsel in terms of billing, to be able to appear by telephone. So, I mean, I think that that's something that can be discussed further at the Territorial Court Users Committee, either at the present time, looking towards the end of the pandemic, or once the pandemic ends. But I think that it's a valid point to be discussed.
And I will say, just as I've heard anecdotally, just with regards to telephone appearances, it does work somewhat better if someone has a landline as opposed to calling from your cell phone, which most people these days have a cell phone, because I do understand that calls were dropped more frequently, or people were having troubles getting through at times on their cell phones as opposed to a landline. So just something to consider. And Kevin Droulet has just said, kudos to the court technologists for how easily telephone appearances are facilitated for non-resident counsel. So I think that's all the questions we have right now. So I don't know if there's just some last comments or thoughts that either of you would like to provide before we wrap this up.
Well, I'd like to thank both Kathy Rasmussen for doing such a great job organizing this, and to David McWhinnie for all the work that he put into his preparation for this talk. And I'm encouraged as well in terms of the number of people that had signed up to attend this talk remotely. So a good use of technology during these tough times. Thank you to everyone.
And as was evident at the beginning, technology can bite all of us. Thanks again, Kathy. Appreciate all your assistance throughout.
No problem. Well, thank you both. We appreciate all your knowledge and your time talking to us all today. So thank you.
Thank you.